My name is Jim Conaway, and this video presentation is being completed for William Woods University EDU 503 Sports Law class. This particular case study for my week 7-1 graded assignment is Jackson versus the Birmingham Board of Education. I found this case interesting in comparison to other cases in Chapter 8 because I believe that a similar number of situations exist in a number of educational institutions. As a general rule, it seems in my experience that educational institutions are indeed aware if they are following the spirit of the law as far as administering the components of Title IX. This also shows that while the individual may decide to formally complain with regard to Title IX and perhaps win a battle of sorts, that it is the educational institution with more power and resources that usually prevails over the long haul. As far as the facts are concerned with this case, Roderick Jackson was a teacher in Birmingham, Alabama public school system. He brought suit against the Birmingham Board of Education, alleging that the board retaliated against him because he complained about sex discrimination at Inslee High School. Jackson, who had taught 6 years prior in the Birmingham School District, was transferred to Inslee High School in August 1999 as a physical education teacher and girls basketball coach. In December 2000, Jackson began complaining of unequal treatment as far as how the boys basketball team was treated in comparison to the girls basketball team. And he began to receive negative coaching evaluations. Jackson eventually was removed as the girls basketball coach in May 2001. As far as the arguments on both sides, Jackson argued that his girls team was forced to practice in an older gymnasium with bent rims and other broken equipment. He also argued that the girls' team was denied a share of money donated by the city of Birmingham to the school's athletic department. His girl team was also forced to travel by car instead of bus that was provided for the boys' team. Jackson alleged that he began receiving negative evaluations after he began complaining, and he was finally removed as girls basketball coach. The school district in turn argued that retaliation was not covered as a part of Title IX policy. As far as the court findings are concerned, the United States District Court for the Northern District of Alabama dismissed Jackson's claims on the ground that Title IX's private right of action does not include claims of retaliation. The Court of Appeals for the 11th Circuit affirmed the district court ruling that Title IX does not provide a right of action for retaliation. Finally, Justice Sandra Day O'Connor, writing for the bare majority in a U.S. Supreme Court decision, held that retaliation against individuals because they complain of sex discrimination is intentional conduct against individuals because they complain of violates the terms of Title IX. O'Connor compared the case to Sullivan versus Little Huntington Park Incorporated, which held the Supreme Court provided a cause of action for retaliation in advocacy for African Americans. Because Sullivan interpreted a general prohibition on racial discrimination to cover retaliation against those who advocate the rights of groups are protected by that prohibition. So should Title IX be read to prohibit retaliation for advocacy on behalf of those subjected to such discrimination. Justice Clarence Thompson, in turn, authored a dissenting opinion where he was joined by 3 others. He argued that the case, which was decided on March 29, 2005, that retaliatory conduct is not discrimination on the basis of sex in the plain terms of Title IX. The favorable ruling, in turn, allowed Jackson to file a complaint of retaliation in the court system. After a 5-year fight, Jackson was awarded $50,000 in damages. His attorneys received $340,000, and the school district implemented new Title IX procedures. The board is estimated to have spent $363,000 in legal fees. Just imagine if some of this money would have been spent to help the girls' basketball program. Everyone could have been saved a lot of time and trouble. Jackson, meanwhile, has filed 3 additional EEOC complaints since 2010, and he claims that he's been permanently blackballed by the school district. There's an unwritten rule, Jackson said in a 2013 interview. Once you rock the boat, you won't get a chance of rocking it again. As far as the implications for the athletic activity administrator are concerned, there are really lots of lessons I feel to be learned from this case. To begin with, it shows the individual for the most part is powerless in terms of attempting to engage in a true fight with the educational institution over Title IX, or it is wiser for other stakeholders, such as parents, and not the employee coach, to fight this battle. The educational institution always has more resources in terms of money, legal, and other powers. It is probably best to talk in subtle ways with the powers to be than to resort to filing formal complaints. Title IX, the Equal Employment Opportunity Commission, Office of Civil Rights, U.S. Department of Justice, as a general rule, is backed up and logged with numerous complaints, and it can do only so much to protect the individual from retaliation.